So guys, the Supreme Court ruled in favor of Tinubu and Shettima on the double nomination issue. They even went ahead to fine the PDP, Atiku, for wasting the court's time. Take a look at this.
We are privileged to be inside the court today, and as a senior journalist, their rights on legal matters, the case between APC and, or rather PDP and APC, what happened today?
The courts are taking arguments on the previous dates. That was on a Monday.
Yeah, stay there.
So today the court then ruled on the issues that was primarily relating to the alleged double nomination vice presidential candidate of the APC, Tinubu Shettima. Now the Supreme Court has maintained today that not only does the PDP lack the local state,
so I should be there. You are insulting a uniform person.
She did not insult anybody. She was arguing with
the so-called double nomination never really happened. According to the panel, which was unanimous agreement panel members, Justice Inyalukuru, Justice Jauro, Justice Amina Algir, Justice Edumiju, and Emmanuel Agim, unanimously held today that the issue of double nomination did not come before adjudication because the person duly notified the party of his intention to withdraw his senatorial candidacy for the new central senatorial district before he was announced as the vice presidential candidate
of the APC.
Following which the party, based on his earlier letter dated 6th of July, forwarded the same to INEC on the 15th. So it was publicly announced on the 14th. And then the letters were forwarded to INEC on the 15th. So what they found was that in looking at the substance of the matter, he had already indicated that he was going to be nominated as vice presidency, and then he was no more interested to retain the ticket of the party for the Senate. So that intention was what they also looked at, that there was no intention to hold down double nominations. And they also claimed, the Supreme Court also held that there was no proof that he actually contested for the vice presidency. Like all along, he was contested for Senate. So there was no proof that he contested for vice presidency, which meant that it was when it became known to him that he was going to be vice presidency.
That's when he
vice presidential candidate, that he then announced or withdrew from the senatorial nomination. So by and large, what we gather here today is that there is no such issue as double nomination pending against the...
Yeah, but many Nigerians are basically saying that it is expected that this is about APC, and it has always been their way of doing things. But looking at it as a judicial reporter and looking into the judgment that they were given, or that was given today, what's now your own personal opinion? Do you think that justice was denied, or do you think that, looking at the legal argument, that there was some merits in the decision of the judges?
There clearly was some merit in this position of Leonard, honorable justices, because there is a principle in law that talks about locus, and that principle is that you must show injury you suffer personally in any action you want to do. So now they are asking the PDP, what was injury you suffered? If you have any injury, it has not even been activated at this stage, because this is a pre-election matter that arose from a primary of a political party. So to that extent, that principle was applied even from the lower courts, that's lower high court, court of appeal, and they also reinforced that principle that there was no locus that could have activated the jurisdiction of the apex court to entertain this matter. So on the basis of all this put together, we can see that was founded in law. No matter what parties one may be sympathetic to, they only apply those principles of the law and interpreted it based on the facts also before them, the letters that were submitted showing withdrawal from senatorial candidacy of the fourth respondent, that is vice presidential candidate of the APC. So, by and large, those findings were actually based on.
So, is it also true that the PDP were fined 2 million naira for wasting the time of the court?
Yes, the PDP were given extra 2 million naira cost. You recall that when this matter came before the Court of Appeal, there was also 5 million naira. And the principle again guiding this is that the Supreme Court said that they are a policy court, and some of the policy decisions they make is to guard against bringing frivolous, what they said in quote, frivolous applications, that the lawyers ought to have known that this matter was frivolous in their own language, because they did not participate, they were not aspirants during that primary. So based on that they want to make that policy, which is to dissuade people from bringing frivolous applications. So that was why they awarded for that 2 million in addition to the 5 million.
That is then called a double jeopardy. The appeal court awarded, High Court awarded them how much? Court of Appeal. 5 million against PDP.
Yes.
The Supreme Court 2 million against PDP, meaning that case ought not to have seen the light of day, ammunition. Okay. Now we are heading to the Court of Appeal for another case that is upcoming. What's time now? What's the time?
11:52.
11:52. So that case will be coming up 12:30. So if you're watching us live now on Ginger Media TV, stay online. We are just driving from here to that place. But this morning, the case between FCT versus the APC and Shettima Tinubu, where the residents of the FCT argue that for the fact that Bola Ahmed Tinubu did not get 25% of the vote, that it is unconstitutional to swear him in as president. Today, something interesting happened, and I want to get your take on this. The judge did an awo on people. People say he ran away. Some people say he didn't show up. So what's your take on that?
That matter was basically to deliver a ruling on referral. That is to refer the matter to the Court of Appeal. That's what the FCT presidents and voters were asking for. So the business of the court was to rule either to refer or to decline to refer. The court perhaps are seeing the submission that were made, because the court earlier had asked them to bring 3 questions.
Yes.
To respond to 3 questions. One of the questions relates to whether there was a locus on their parts
And jurisdiction?
to jurisdiction, and whether there is already a similar matter
In the Presidential Election Tribunal.
to interpret 25%
Yes.
in the FCT, any other place.
That's correct. I was in court that day, yes.
So perhaps looking at those questions that these people have submitted the responses to, the court in this wisdom felt that it was better to leave it to the tribunal, to the presidential court to entertain.
But the court should say so. If that becomes what the court is thinking, they should say so.
That raises another issue of
Judicial independence.
not just judicial independence, even issues of fair hearing, because if the party has come before the court, they expect the court to decide that matter one way or the other. When that does not happen and the time lapses, where is the fair hearing, where is the justice of the matter? So that is left for judicial policymakers to look at in the future, that if there is such application, it is bound on the court to rule one way or the other. To abandon it that way.
We are just hoping that, the Supreme Court will take its time to look at these petitions and do the needful. And this is why people keep saying, why inaugurate when the court is still looking into this matter? People prefer that the court should conclude all these things before any inauguration takes place, but from the look of things you can see the opposite happening. Please don't forget to subscribe to my channel, turn on the notification bell. Please give this video a like so that YouTube can recommend it to others, and let me know what you think in the comment section below. Thank you.